Hey, everybody. I know I said I wasn't going to be live, but look, I've just come across something that I've gone, oh, I could tell everybody about. So welcome. I know this is unplanned, unexpected. We've just done a premiere of a video. Thank you to Rick for his amazing editing. He makes the video look amazing. So thumbs up to Rick. So a couple of days ago, I said to you that there was a man that was suing the federal government because they had imposed a ban from India. So at the moment, the Australian government has banned everybody, citizens, everybody, permanent residents, from returning to Australia. Then they discovered that there was a loophole and people coming in from Doha and other places. So they closed that loophole. But a man has decided to challenge that. And I've got the court documents have been released under general interest. And that's what I want to look at today, because this court case has been expedited. This has been expedited from the court. Now he's taking on it says Gary Newman versus Minister for Health and Aged Care. So he's taking on the aged care minister. So we're going to look at these documents. So these have all been expedited. So again, they go through and they make sure that all the documents contain nothing that needs redacting, and they will redact them. So this is the notice of filing. Again, this is in the New South Wales registry. Every state in Australia has a registry. Everything filed in the federal court has to have this notice, this header. It needs to have this cover sheet. And if I'm sounding a little bit under the weather, I am. So I apologise. So this is an originating application. This says to the respondent, the applicant applies for relief set out in this application. The court will hear this application and make orders for the conduct of the proceeding at the time and the place stated below. If your lawyer do not attend, then the court may make orders in your absence. You must file a notice of address for service and that. So, right, so here's our claim. On the grounds set out below and facts set out in the accompanying affidavit, the applicant applies for the following relief under Section 39B(1)(a) of the Judiciary Act 1903, Commonwealth, or further or alternately under Section 21 of the Federal Court of Australia Act 1976. A declaration that the whole of, or alternatively, Clause 6 of the Human Biosecurity Emergency Human Coronavirus with Pandemic Potential, Emergency Requirements, High-Risk Country Travel Pause, Determination 2021 Commonwealth, purportedly made pursuant to Section 447 of the Biosecurity Act 2015, insofar as it applies to the applicant, is invalid and no effect by reason that the respondent failed to have regard to or to consider properly the statutory preconditions to the exercise of power as set out in Section 4474 of the Act, or in order to be satisfied that it was necessary for the respondent to determine a requirement to prevent, control the entry, emergence, establishment or spread of a declaration listed human disease under Section 447, the respondent was required to be satisfied that the matters set out in Section 4474 of the Act. The respondent failed to consider whether determination was appropriate and adapted to achieve the purpose for which it is determined by Section 447, by failing to take into account the public health concerns arising from the determination, including the ability of the Commonwealth or state governments to manage the risks of infections within prison populations where persons potentially infected by COVID-19 are detained or taken into remand on suspicious of committing an offence pursuant to Section 479 of the Act for failure to comply with the determination. The failure in 2 above is to be inferred from the fact that the respondent received advice from the Chief Medical Officer by letter dated April 30, 2021, and the advice contains no advice or consideration of that risk. The respondent failed to consider whether the determination was no more restrictive or intrusive than the requirement in the circumstances as required by Section 4474C, by failing to take into account whether there was less restrictive and onerous means to manage the public health risk, other than prohibiting entry into Australia by Australian citizens who had been in India in the preceding 14 days, and imposing by operation of Section 479 of the Act criminal penalties in respect to non-compliance of determination. So remember that the government stated that anybody that breached the ban, so if you travelled from India to Australia and you were caught, you risked 2 years in jail and a huge fine. So this man is in India at the moment. He's Australian, and so he's taking on the government and is suing the government, or is trying to get that ban overturned. And the lawyers are working for free on this. The failure in 4 above is to be inferred from the fact that the respondent received advice from the Chief Medical Officer by letter dated 30th of April 2021, and advice that notes that a determination, if made, would be the first time that such a determination has been used to prevent Australian citizens and permanent residents entering Australia. So this is the issue that people have, that Australian citizens and residents cannot get back into Australia at the moment because of the ban. So there are countries that have put in a ban in place, but they've allowed their citizens and residents to return. At the moment, until the 15th, nobody can travel from India. Also, there was a report today that an Australian citizen has died in India. They're just got to determine whether it's COVID related. So, notwithstanding 1 and 2 that states the Chief Medical Officer was satisfied that the determination made under Section 477 of the Act to make an offence for a person to enter Australia if they'd been in India in the preceding 14 days is necessary to prevent and control the entry into, the emergence, establishment or spread of COVID-19 in Australia. And being the same matters, the respondent is required to be satisfied before making a determination. Further particulars will be provided following production by the respondent. The determination otherwise exceeded the power conferred to it in the Act. So the first point that they made was that they didn't consider the regulations. This one is that now they've exceeded their powers. It wholly prohibits entry into Australia rather than imposing requirements upon re-entry as authorised by Section 4473A of the Act. So at the moment, if you enter Australia, you have to do a 14-day quarantine period in the state in which you enter. So that's how that is. Insofar as it purports to restrict or prevent movement of persons or between specified places, such as authorised by Section 4773B of the Act, the determination is purported to operate extraterritorially by restricting international travel between India and Australia in circumstances where Chapter 8 of the Act does not have any extraterritorial effect. The declaration that the whole of the determination, or alternatively, such parts of the sections 477 and 479 of the Act, in as far as they apply to the applicant, are invalid and of no effect by reason that they offend the principle of legality insofar as they purport to abrogate a fundamental common law right of citizens to re-enter their country of citizenship in circumstances where the Act does not elsewhere, whether by clear words or necessary implication, purport to abrogate such right or grant the respondent the power to abrogate such right. Gee, they're using big words here, aren't they? Section 479 of the Act has the effect of imposing a criminal sanction on Australian citizens for the act of seeking entry to Australia where the offence has been created by means of a legislative instrument made under 477. 4772 of the Act disapplies Section 42 of the Legislation Act 2003, such that the determination is not subject to parliamentary oversight by means of a notice of motion to disallow the legislative instrument. In the alternative, a declaration that the whole of or alternative clause 6 of the determination, insofar as it applies to the applicant, is invalid and no effect by reason that it was not within the scope of what Parliament intended when enacting the Act, nor reasonably proportionate or appropriate and adapted to achieving legitimate legislative ends in circumstances where alternative, less restrictive and intrusive measures were available to the respondent to manage public health risk to which the term is purportedly addressed. So they're saying they had other considerations, and they're like, well, they do have other considerations. As I said, at the moment, you have to come into this country, you have to do 14 days. No consideration was given by the respondent to domestic public health concerns arising from the determination, including of the ability of the Commonwealth or state governments to manage the risk of infection within prison populations where persons potentially infected with COVID-19 are detained or taken into remand on suspicion of committing an offence pursuant to Section 479 of the Act for failure to comply with the determination. Now, it's interesting. I was speaking to a prison chaplain just recently, and he was saying that anybody that goes into prison has 14 days of solitary confinement, whether they come from another prison to prison or whether they come off from the street into prison. Even prisons have to do a mandatory 14-day quarantine. So if you go into prison, if you get arrested, and you have to do a quarantine period. So that's really interesting. The determination has the effect of imposing a criminal sanction on Australian citizens seeking to re-enter Australia. So this is the whole beef, the fact that there's sanctions for Australians that want to come home. By reason of Section 4772 of the Act, the determination was not subject to parliamentary oversight or disallowance pursuant to Section 42 of the Legislation Act Commonwealth. So they're saying it actually didn't go through Parliament. It's something that the government just made. In the alternative, a declaration that Section 477 of the Act and alternatively the determination insofar as applies to the applicant is invalid and no effect by reason that the section or the determination impermissibly burden the implied freedom of citizens to enter Australia granted to all citizens under Commonwealth Constitution. The section or determination exceeded the legislative power granted to the Commonwealth Parliament under Section 51 of the Commonwealth Constitution, in that no head of power nor implied source of power is capable of sustaining Section 44 of the Act of Determination. So here's what they want. So the applicant seeks claims of interlocutory relief, an order that at the time of service, the original application filed 5th of May and all affidavits in support to be abridged to 6 p.m. 5th of May. A direction pursuant to R504 of the Royal Court Rules that the proceedings be expedited. They are. An order that the respondent produce to the applicant on or before the 4 p.m. 6th of May, as if under a notice to produce, served accordingly, all materials and guidelines subject to any claim for legal professional privilege relied upon by the respondent in making a determination and reaching the state of satisfaction as required by Section 4774 of the Act. An order pursuant to of the Federal Court Rules that prayers 1 and 2 of this originating application be heard separately from the other prayers for relief and be listed for the final hearing and time to be fixed by a duty judge no later than the 13th of May. So they filed this court. So they filed this and they've asked for expedition. Now, they want this all done by the 13th of May because the ban, the travel ban, finishes on the 15th of May. So it has to be all done and dusted by the 13th. They want this all sorted out. So here's the affidavit of the lawyer. I think this is the lawyer that's acting on his behalf. So remember, The person, Gary Newman, is currently in India. That's where he is. Now, he's saying he's actually stuck in India and he can't get home because of the travel ban. And previously, before the travel ban, the government had reduced flights, repatriation flights by 30% from India. So this is the solicitor. So this is the 5th of May. So it looks like he's got an Australian passport, UK passport, his visa for India, and his flight. Then we've got some letters here as well. Okay, so as I said, they redact all the personal information from here. This is what the court does, and this is filed under a public interest site. So it says, I, Michael Bradley of Level 4, 343 George Street, New South Wales, say on information and belief that I'm a solicitor for the application in these proceedings. I'm authorised to make this affidavit on behalf of the applicant in relation to his originating application dated 5th of May 2021. I am informed by the applicant of each of the matters in paragraphs 4 to 22 below and believe them to be true. So he's relying on the information from the applicant and that he believes them to be true. So the applicant is an Australian citizen. He holds a passport from the Commonwealth of Australia, which passport and then redacted. A copy of his Australian passport redacted is annexed to his affidavit and marked MB1. The applicant was born in Melbourne. His brother's family, ex-wife, ex-partner, stepson, paternal relations all reside in Australia, as well as his former colleagues and many of his friends. The applicant also is a citizen of the United Kingdom. He holds a passport from the United Kingdom, which passport redacted. A copy of his United Kingdom passport redacted is annexed to this affidavit and marked MB2. The applicant has 2 sons who live in the United Kingdom and voluntarily acquired his citizenship of the United Kingdom through his maternal ancestry in order to have the ability to visit his sons and other children without visa restrictions. The applicant has not visited the United Kingdom over the 2 years and identifies as primarily an Australian citizen. The applicant holds a visa granted by the Republic of India and a copy of the visa is annexed. Arrival in India and attempts to depart. In early March 2020, the applicant flew from India to Melbourne via Singapore, disembarking at the Kembagowda Airport, International Airport, Bangalore, on the 6th of March 2020. Copy of his airline ticket stub showing his name, date, and port of embarkation is annexed to his this affidavit marked MB4. The purpose of the applicant's travel was to travel to India to visit friends. At the time of the applicant travel to India, he intended to remain in the Republic of India for the permitted duration of the visa, being 180 days. The applicant has remained within the Republic of India since his arrival on the 6th of March to present day. The applicant did not attempt to book a return flight to Australia prior to November 2020 because he understood that airlines were not operating regular scheduled passenger flights from India to Australia. In or around November 2020, the applicant booked an Etihad flight to Melbourne via Abu Dhabi. The time of booking, the applicant understood that airlines had recommenced operating scheduled passenger flights from India. Approximately 1 week after the applicant had booked his flight to Melbourne, Etihad cancelled the applicant's flight. The applicant currently holds $1,200 in credit with Etihad as a result of the cancellation of his flight. The applicant presently resides in the city of Bangalore, in the state of Bengaluru, in the state of Karnataka. Sorry, I'm messing up these pronunciations. The applicant is 73 years old and accordingly is at a high risk of suffering severe illness or death if he contracts COVID-19. On 3rd of May 2021, the city of Bengaluru recorded approximately 22,000 new cases of COVID-19. The applicant has not left his residence in the past 12 days as he's fearful of contracting COVID-19 and suffering severe illness. He'd be willing to leave his residence for the purpose of travelling out of India. The applicant would like to fly home to Australia. On April 27, 2021, the Prime Minister of Australia announced a ban on direct flights from India to Australia. After the announcement, the applicant considered travelling to Pakistan in order to fly from Pakistan indirectly to Australia. The applicant is aware that the determination, as defined in the originating application, purports to make it an offence for him to travel from any place, including Pakistan, to Australia, if he has been in the Republic of India within 14 days before the day any flight from that place is due to commence. I've obtained a letter from Professor Paul Kelly, Chief Medical Officer to Minister Hunt, dated the 30th of April 2021. A copy of that letter is annexed to this affidavit and marked MB5. I understand that on the 30th of April 2021, the Office of the Director General of Civil Aviation, Government of India, issued circular whereby it suspended all scheduled international commercial passenger services to and from India until 11:59 p.m. on the 31st of May 2021. A copy of the circular dated 30th of April 2021 is annexed and marks MB6, and a copy of the earlier circulator to which it refers, dated 26th of June 2020, is annexed and marks MB7. On the 5th of May 2021 at 12:24, Kira Peacock of Mark Lawyers provided a copy of the unfiled originating application dated 5th of May 2021 to the Australian Government Solicitor on behalf of the Minister at this address. In that email, Ms. Peacock advised that we would be filing the originating process today and duly approaching the duty judge of the Federal Court of Australia at 3 p.m. on the 5th of May 2021 to seek the interlocutory relief in the originating application. So there we go. So we've got, so this should be all redacted. Yep, there you go, redacted. So that's the passport. This one is the UK passport. This one I think is, we had the ticket stub and there's also the visa. So we don't need to know all that. So this is, a letter from the Chief Medical Officer. Dear Mr. Hunt, I'm writing to provide advice to assist your considerations to make a determination under Section 477 of the Biosecurity Act 2015 to make an offence for a person, including Australian citizens and permanent residents, to enter Australia if they've been in India in the preceding 14 days. I note that such a determination, if made, would be the first time that such a determination has been used to prevent Australian citizens and permanent residents entering Australia. So on the 27th of April 2021, the Prime Minister announced new measures in response to the worsening COVID situation in India. The new measures include a temporary pause on all direct flights from India to Australia, which include Australian government-facilitated repatriation flights until the 15th of May. I note that although Australia has already implemented a ban on direct flights from India, flights through transit hubs continue to provide an avenue for individuals who have recently been in India to enter Australia. It is important in any measure we implement that we balance the burden on our quarantine and health systems and the protection of our community with the needs to help Australians get home, including those currently residing in high-risk countries. On 18th of March 2020, the Governor-General declared a human biosecurity emergency in relation to the global outbreak of listed human disease, human coronavirus with pandemic potential, under Section 475 of the Act. This declaration enlivens the power for you to determine emergency requirements and directions under the Act that are necessary to prevent or control the entry into or the emergence, establishment or spread of COVID-19 in Australian territory or part of the Australian territory. The declaration was recently extended by the Governor-General until the 17th of June 2021. Now that's interesting. So during the human biosecurity emergency period, in accordance with Section 477 of the Act, you as the Health Minister may determine requirements that you consider are necessary to prevent or control the entry into or the emergence, establishment or spread of COVID-19 in Australian territory or part of Australian territory. The Act provides that before determining emergency requirements under subsection 4771, you must be satisfied that any requirements are necessary to prevent or control the entry into the emergence, establishment or spread of COVID-19 in the Australian territory or part of an Australian territory. The Act also requires that you are satisfied that the requirements are likely to be effective in or contribute to achieving its purpose, appropriate and adapted to the purpose, no more restrictive or intrusive than required in the circumstances, are applied in a manner that no more restrictive or intrusive than required in the circumstances and are in place for as long as necessary. The penalty for breaching 477 determination is 5 years jail or 300 penalty units or $66,600 or both. So this is what this is at the moment. If you're caught coming into Australia from India within the preceding 14 days, this is what you can be charged with. So this is a letter from the Chief Medical Officer, which is the person that is advising the government. Hello to everybody that's watching. I've been focusing on this. So this is we're just looking at a court matter between an Australian citizen who is in India at the moment against the Australian government, because the Australian government have banned all flights to and from, direct and indirect flights from India, and Australian citizens can't get home. Medical advice to support S44477 determination. COVID-19 continues to represent a severe and immediate threat to human health in Australia. COVID-19 has the ability to cause high levels of morbidity and mortality and disrupt the Australian community socially and economically. The number of new COVID-19 cases recorded globally continues to rise at an alarming rate. There are over 149.1 million cases of COVID-19, with over 3.1 million deaths recorded, an approximate crude case fatality of 2.1%. India has been identified as a high-risk country due to significant increase in COVID-19 positive case numbers in return travellers from India. India has recorded over 18.3 million positive COVID-19 cases and over 204,000 deaths, with daily case numbers reached global records this week. 379,257 new infections and 3,645 deaths on April 29, 2021. Following the introduction of pre-departure testing and changes to international arrival caps in late 2021, overseas acquired cases among air arrivals fell from approximately 1% to 0.5% in February 21. This proportion has since increased, with approximately 1.8% of recent air arrivals being identified as cases between the 19th and 25th of April 2021. Since late March 2021, there has been a sharp increase in the number and proportion of overseas acquired cases that were reported as acquiring their infection in India. Over 50% of overseas acquired cases since mid-April 2021 were acquired in India. There have been a range of emerging risks associated with international arrivals, including particularly those who have been in India, arising from the following circumstances: the continued rapid increase and likely underreporting of numbers in COVID-19 cases in India through community transmissions, lack of verification mechanisms for negative COVID-19 test results obtained internationally, high rates of COVID-19 detected from arrivals from India, with a high proportion of overseas acquired cases detected in Australia having acquired their infection in India, high proportion of variants of concern and variants of interest amongst those cases, and community transmission within hotel quarantine as seen recently in New South Wales and Western Australia. Each new case identified in quarantine increases the risk of leakage into the Australian community through transmission to quarantine workers or other quarantined returnees, and subsequently into the Australian community more broadly. This quarantine leakage presents a significant risk to the Australian community. Of particular concern, New South Wales and Western Australia have recently seen COVID-19 transmitted in hotel quarantine facilities as two sets of guests in rooms opposite each other had the same sequence of virus despite arriving from different countries at different times. Australia's quarantine and health resources needed to prevent and control COVID-19 introduced into Australia from international arrivals are limited. Due to the high proportion of positive cases arising from arrivals from India, I consider a pause until the 15th of May on arrivals from India to be effective and proportionate measure to maintain the integrity of Australia's quarantine system. This measure will likely allow the system to recover capacity, which is a critical intervention in preventing and managing the spread of COVID-19. In line with the Prime Minister's announcement of a temporary pause on all direct flights from India to Australia until at least the 15th of May 2021, the determination, if made, will be in effect for a limited duration, 15th of May 2021. Given the proposed limited duration of the determination, I am satisfied this meets the criteria that such an emergency requirement is in place for as long as it is required. I wish to note the potential consequences for Australian citizens and permanent residents as a result of this pause on flights and entry into Australia. This includes the risk of serious illness without access to healthcare, the potential for Australians to be stranded in a transit country, in a worst case scenario, deaths. I consider these serious implications can be mitigated through having the restrictions only temporarily in place, i.e. a pause, by ensuring there are categories of exemptions. I recommend the determination that allows exemptions to the pause on travel for the following class of persons: a member of a crew or an aircraft or vessel, a worker associated with the safety or maintenance of an aircraft or vessel, a person engaged in day-to-day conduct of inbound, outbound freight, a person, including a member of the Australian Defence Force who's travelling on official government business in Australia, official or diplomatic passport, a person or who is immediate family to a person above, a diplomat accredited to Australia, a person who is an immediate family member of a diplomat accredited to Australia who holds a SUED Class 9595 diplomatic temporary visa, a person who is an immediate family member of a diplomat accredited to Australia who holds the subclass 995 diplomatic temporary visa, and member of the Australian Medical Assistance Team. The recommended exemptions will ensure the above determination is appropriate and adapted to the purpose, no more restrictive or intrusive than required in the circumstances that is applied in the matter, that is no more restrictive or intrusive required in the circumstances. I am satisfied that the determination made under Section 477 of the Act to make it an offence for a person to enter Australia if they've been in India in the preceding 14 days is necessary to prevent and control the entry into or the emergence, establishment or spread of COVID-19 in Australia. I recommend that you, in your capacity as Health Minister and Aged Care, agree to make this determination. And this is signed Professor Paul Kelly, the Chief Medical Officer. So it's the Chief Medical Officer that the government relies on and takes his advice to make. Hello, Diamond Crystal Arts. How are you? We're just looking at the lawsuit from the citizen in India who's suing the government. So this is okay, so this is his visa. However, international scheduled flights may allow be selected route. Please acknowledge the receipt of strict compliance. This is a circular travel and visa. So again, this is a government of India. So this is again is a determination in the continuation dated 30th of May 2020 on the subject above. The international commercial passenger services to and from India shall remain suspended until the 15th of July 2020. This restriction shall not apply to international or cargo. So that is the affidavit from the lawyer. So I'd be interested in what you think, what your thoughts are on the matter. Should the government have stopped citizens from returning home? Is it applicable to try and stop, because there has been some leakage of the virus into the community? Is it applicable? Is this guy, he's been in there since March 2020, and he admitted in the affidavit he didn't book flights. Then he tried to fly home in November. They suspended flights. And, I mean, did he try hard enough to get home? That's what I'm interested in hearing what you think. So on the 6th of May, there was an order made. And this is, I'm expecting this to say that's been expedited. So as I said, they've wanted it to, so this is from Chief Justice Alsop. Unless the court orders that, unless the court otherwise orders no person being a member of the public who is observing the hearing of the proceedings by accessing any audio video link, including link by the platform Microsoft Teams, may make any audio or video recording or photograph of the hearing, any part of it, participate in or interrupt the hearing, provided that nothing in this order shall prevent any person based on what he or she has seen or heard during the hearing, making his or her notes or recording of the proceeding, publishing a fair report of the proceeding. On or before 3 p.m. the 7th of May 2021, the applicant served on the respondent any evidence by which of way of affidavit or tender bundle upon which he intends to rely. Any part of the evidence that is ready for delivery earlier than 3 p.m. should be served on the respondent when ready. On or before 3 p.m. the 7th of May, the applicant serve on the respondent his written submission in such form as is available at the time. The submissions shall be served earlier if they're ready. On or before 9 a.m. the 10th of May, the parties shall file an electronic court book containing all the relevant, and the matter is being listed for hearing on the 10th of May at 12 noon. The parties have liberty to apply to list the matter before Justice Thorley's on 1 hour's notice. A contravening of Order 1 may constitute in the contempt of court and be punishable by imprisonment, fine, or sequestration of property. Wow! That's Order 1. That's if you... Oh, wow. You could, so if you record or take a photo of the hearing, this hearing, they could actually take your property. Interesting. Wow. Senior counsel for the applicant has indicated the way the matter is put on the transcript today, which needs to be read in clarification of prior to it. Particularly, senior counsel indicated that there is no constitutional question arising whether substantively or by way of construction that would require an issuance of a notice under 7 out of the judiciary. In other words, there is no constitutional issue issued to be directly raised or indirectly raised by the press. So this is scheduled to be this is scheduled now to be heard on the 10th of May at 12 noon. Oh, that's Monday. Huh. So this is going to be dealt with on Monday. So we're going to find out on Monday whether or not the federal court is going to going to support the what the government's done, or they're going to say that's unconstitutional. So thank you for watching. I know this was a really unplanned live. I should have been doing my assignment, but this is more fun. So thank you for watching. Look, please make sure that you like and subscribe and do all the YouTubey thingies and whatever. I know I say it every day, but thank you for your support, continued support. I just really, really appreciate it. We'll be back to normal programming soon. But in the meantime, please check out some of the other videos. And as I said, please leave comments below on your thoughts on the matter. What do you think? A lot of Australia's cases, Australia's just started to get a few community transmissions now. New South Wales have got a few little issues there. WA had another lockdown just recently. That was due to quarantine facility community transmission. I know that, and I think the chief health officer, what he said is the more positive cases we're getting in hotel quarantine, the more likely it is to spread into the community if it spreads into the community. I understand what the government's doing. I mean, I'm a little bit mixed in the fact that I sort of go, well, and a lot of people in Australia are saying, well, he had plenty of time to get home. Is it the Australian government's fault that India stopped flights or flights were cancelled or whatever? what they're trying to do is to give the quarantine system a little bit of a break. So the stats state that 50% of all positive cases of COVID at the moment are coming from India. And that's where, and we know that strain is deadly. So I'm a little bit, I have to say, I'm a little bit of a fence sitter. I understand the issue. I understand the problem. I'm just glad I'm not having to make these decisions. That's all I say. The other thing is there's another, one of the franchising businesses in Victoria is suing the state government for the lockdown over lost revenue and lost business. So the implications and the legal challenges, I think, are just starting. So this is going to be a very interesting one and could actually set the standard of further and more legal things happening. So as I said, I'd be interested to see what you think. Please let me know in the comments below. Thank you very much again, and I will catch you. I'll catch you live soon. If all goes well, I'll be live tomorrow night, and we'll be back to our normal fun. But otherwise, there'll be another recorded. I've been recording. I record stuff sometimes that we can use. So otherwise, there'll be another premiere. But anyway, thank you all for your love and support, and I will catch you next time.